lady, before I commence, I wish to clarify an aspect which was raised by the court yesterday, and that related to the consultation which took place with the psychiatrist engaged by the defense, Dr. Marissa Peter, and Mrs. Newcomb, or Mrs. Nader. And the court, I think, questioned the correctness of that or the proprietariness associated with that. Unfortunately, I was not personally involved in this case at that stage because the consultation took place, I understand, during September 2016, and I only became involved in this case for the first time in September 2017. But I have made inquiries, and my instructing attorney in Johannesburg, Mr. Daniel Witz, has advised me, and I have every reason to accept what he says, and that is that Advocate Karim Tennyson, who was initially the state advocate involved in this matter, provided the defense with a list of state witnesses in August 2016. I have a copy of that list here. It comprises some 30 witnesses, and neither Mrs. Nader nor Mrs. Newcomb's names appear on that list. The same applies to Dr. Steenkamp. Thereafter, the consultation took place, as the court is aware, and an updated list of witnesses was provided by the state via my learned friend, Mr. van Niekerk, in terms of which the names of Nader and Newcomb and Steenkamp appeared for the first time, and that list was only provided in June or July 2017. I suspect that that list was provided together with the indictment and the substantial statement of fact. That list was then amended, and an amended list was provided by Mr. van Niekerk some 3 days before the trial to include Dr. Abrams and a Mr. Einhorn. And I might just mention, as a matter of interest, that in the original list of Advocate Tennyson, Dr. Abrams' name did appear. Then it was removed and did not appear in the final list that was provided by my learned friend, and then in his revised list it appeared again. And I shall deal with the implications of that in due course. The indictment, which was provided together with a substantial statement of fact, is not dated, unfortunately, but according to Mr. Witz, it was provided to the defense on the 25th of July 2017, and I believe that the...
Sorry, give me the date, 25 July.
25 July 2017, my lady, and I believe that that the list which incorporated Nader and Newcomb and Steenkamp's names for the first time came with that. I have available, if the court would like to look at it, the copy of the original list that was supplied during August 2016, but I'm sure the court will accept me if I say that their names do not appear in that list. Thank you, my lady. I don't think
we will
there's...
hear from, if necessary.
My inquiries dovetail what the defense has said. I've also got that list of 30 from Advocate Tennyson yesterday. I spoke to the magistrate Jacobs because it was not attached to the court papers, as I indicated yesterday from the record. So I accept what is said on this aspect, my lady.
proceed, Mr. Principal.
Sorry, my lady, while I'm on my feet, there was this aspect of the numbering in Captain Hubert in the photographs. I've clarified it, but I just want to show what I've ascertained to the defense, and then I'll place it on record.
Thank you. Mr. Principal.
Thank you, my lady. My lady, the court has my brief heads of argument in its possession.
Yes.
And what I plan upon doing today is to deal in more detail with various aspects arising from the heads of argument, and certainly I do not intend to regurgitate the contents of my heads. We have an indictment. Earlier, the accused is accused of having, and I quote, killed Susan Frances Rohde, an adult female, by manual strangulation and or inflicting other violence unknown to the state, defeating or obstructing the course of justice or the administration of justice. Now, at the outset, upon receipt of the indictment, together with a substantial statement of fact and the list of witnesses, a request for particulars was filed by the defense. I take it that the court has a copy of that document in its possession. It is dated the 1st of September 2017, and I'm saving to refer to one item in it, and that is, with reference requested, the defense requires the prosecution to specify exactly what it alleges to have been the cause of the deceased's death. If the prosecution cannot confirm this specifically, then to explicitly state this and give reasons why. And then, does the prosecution rely exclusively on the findings and opinions of the state's forensic pathologist in the above regard, as contained in his post-mortem examination report? That is, of course, Dr. Khan's report. And then lastly, insofar as the cause of the deceased's death is concerned, exactly what does the prosecution mean or intend to mean by its use in the indictment of the following words, inflicting other violence unknown to the state? Now, the reply by the state, which incidentally was out of time, but that's not a point that I'm laboring now, dated the 22nd of September 2017, essentially amounted to a refusal to furnish any further information in that regard. And we read the following. The state submits that it is not necessary to address this aspect in a request for further particulars to enable the accused to properly plead to the charges. Secondly, the state submits that the indictment is clear and that the accused can properly plead to the charges contained therein. The state will also argue that the summary of the substantial facts in this matter is not vague and or ambiguous, and I'm quoting there. And then lastly, these questions are a matter of evidence and interpretation that the state witness, Dr. Khan, has made reference to in his records already provided to the defense. Subsequent to that, as the court is well aware, there was a meeting of the parties in chambers, in your ladyship's chambers, and with a view to attempting to resolve various difficulties with regard to the furnishing and provision of requested particulars. A further letter was addressed, which I incidentally drafted, but which was sent on the letterhead of my instructing attorney to my learned friend. And essentially, the following is stated. The defense respectfully rejects the state's response. The defense is entitled to know what the state's case against the accused is, insofar as the alleged cause of the death of the deceased is concerned. The state is required to state exactly what its case is in this regard. Simply put, what, according to the state and in terms of the prosecution case against the accused, was the cause of the deceased's death. There was a response filed to that, incidentally, which was dated the 27th of September, and this was headed second reply by the state, dated the 7th of October, which is a day or two before the trial commenced, and it said the following: the state's answer remains the same, and then it went on to say the following, and is further intensified by the state witness Dr. Abrahams in her affidavit. Now, there can be a debate as to what is meant by the words "and is further intensified by the state witness Dr. Abrahams," because by then she had appeared on the revised list that was provided to the defense, whereas prior to that she had not been included. In the proof of its case and in relying on a conviction to the terms of any particulars that it furnishes. And if I look at the request for trial particulars and the replies thereto, and in particular the words, the state's answer remains the same and is further intensified by the state witness Dr. Abrams in her affidavit. To my mind, this can only indicate that, according to the prosecution, the deceased's death was consistent with manual strangulation and that the ligature indentation on the neck was consistent with a post-mortem placement, because that was Dr. Abrams's conclusion. And it is my submission that the state, in attempting to prove a case, is indicated in my heads. It appears to me as if this case, in the main, centers around two central aspects. What caused the death of the deceased? In other words, was she manually strangled, or, to take it more broadly, did the accused perpetrate some other violence, that is on the one hand, or did she die at her own hand? And I will deal with this more fully later on, by committing suicide, conduct on her part. Incidentally, it is significant that at no stage in her affidavit did Dr. Abrams use the term or refer to smothering. Now, I raise these points because as I stand here today, 1 year after the trial commenced last year in October, and against the background of those requests for further particulars, the wording of the indictment, and the responses which were received from the state, as I stand here today, I still do not know what, according to the state, was the cause of the deceased's death. You will recall that yesterday this was effectively conceded in argument by my learned friend, and it was instructive that it was to be noted that when he cross-examined the accused, he never once even put to the accused the main case for the state, namely that he manually strangled his wife. What he did repeatedly put to the accused, and repeated in his argument yesterday, was that his wife was argumentative, noisy, upsetting him, and he wanted to shut her up, and in consequence he smothered her. Now, he conceded that actually the state doesn't know what caused the deceased's death. And I would submit that that signals a fatal flaw in the case of the state. For the record, in the context of this case and in general forensic pathological terminology, manual strangulation means the following, or let me say death by manual strangulation following. An attacker applies his hands, or a hand I suppose, around the neck or the throat of the victim and applies force and pressure until the unfortunate victim succumbs through any one of a number of possible medical. Ligature strangulation as used in this case, and an example is of course the report of Dr. Perumal, refers to the application of a ligature around the neck of the deceased whilst still alive, and the application of force through that ligature by means of the weight or partial weight of the deceased, depending on whether we are dealing with a complete or a partial hanging or suspension, thereby causing the... And smothering is the process of killing a person by effectively blocking or obstructing his or her external airways. In particular, of course, the nose and the mouth, and this is done with some or other object. It could be a hand or hands, it could be a pillow or whatever. This prevents the person from breathing in and out with obvious consequences. Now, in this case, it is the contention of the defense, and has consistently been the contention of the accused, that the deceased, by hanging herself with the use of the cord of her electric hair iron. Respectful submission that upon an objective analysis of the evidence relating to this matter and a proper comparison thereof, that this is not just a case where the state has succeeded in proving its case beyond reasonable doubt. It is my respectful submission that the evidence overwhelmingly points of proven points that I want to make today. It is my submission that the accused's testimony was completely in line with his plea explanation as well as his prior statement, and I submit that upon a proper analysis, the accused's version of events is supported and corroborated by all objectively determined facts and evidence proven during the trial. And in that regard, for example, I include the following. All the DNA evidence that was produced and is a matter of record, all the expert fingerprint evidence that was produced and is a matter of record, the telephone records that were produced, the SMS records that were produced, the Spuy hotel telephone records, the blood splatter evidence, and various other admitted items of evidence. Before I look at Dr. Khan's testimony as the first pathologist whose opinions need to be evaluated, may I refer the learner and the main legal principles involved here. Once again, I do not intend to reiterate all the points that I've made here. I do, however, wish to add one or two legal points which are, of course, very trite, and they are the following. It is trite law that justice must not only be done, but must also manifestly be seen to be done. It is trite law that an accused person is presumed innocent unless and until proven guilty. And I submit that it flows from this is entitled to be treated as such. And I would submit the treatment of my client at the hands of the South African police, this is something that was sadly absent in the present case. I shall deal with that later in my address. Another point that I wish to expand on relates to evaluation of the evidence of a single witness, and in my heads I referred to the of Rex versus Mokoena, in which it's a very, very old case, in which, and it is by section 284 of Act 31 of 1917, that is, as the Criminal Procedure Act then was. But in my opinion, that section should only be appellate division, and also the case of State versus Weber, also an appellate division case, where the reference is 1971, volume 3, South African Law Reports, page 754, appellate division. And if I can refer the learned court to Zeffert, Pays and Skeen, the South African Law of Evidence, which was formerly, of course, Hoffman and Zeffert. And page 800 in particular, maybe I should say from page 799 to 801, but at the bottom of page 800 in particular, we read the following. It is submitted with respect that there can be no doubt whatsoever that the proposition in the 1932 Mokoena case applies, but only as qualified in State versus Weber and State versus Sauls and other decisions. And essentially what it amounts to is the following, that whilst there is need for caution in such cases, the ultimate requirement remains proof beyond reasonable doubt. And if I could quote from State versus Sauls, there is no rule of thumb, test or formula to apply when it comes to a consideration of the credibility of the single witness. And then that and other decisions go on to say the cautionary rule may be a guide to a right decision, but does not mean that the appeal must succeed if any criticism, however slender, of the witness's evidence were well-founded. And I support that approach wholeheartedly. And I must point out that this authority also indicates the following. On page 801, a point of some interest arise where there is more than one witness in a case, but only one who testifies on a point in issue, whilst the evidence of the others relates to peripheral matters that a peripheral matter that has no bearing on the credibility of the crucial witness. It is submitted that he or she has to be treated as a single witness, precisely because the single witness rule is not a rule of law but reflects common sense and a recognition of the danger inherent in having to rely on a single witness, and as a consequence the caution that the courts require in dealing with this. Now, Those comments are particularly apposite, I submit, with reference to the evaluation of the evidence of Mr. Daniels. And it will be my argument that with reference to Mr. Daniels, the entire spectrum of his testimony was unsatisfactory and flawed, from major material aspects to peripheral aspects. That even if we ignore the peripheral aspects, for example, he's telling a blatant untruth about whether he had lunch with somebody else or not. If we ignore those as peripheral, irrelevant, when we get to the core of his evidence, it is fundamentally flawed and certainly not of a quality that this court can rely on. Now, with regard to circumstantial evidence, I have dealt with that in my heads, but I just wish to emphasize Principles of Evidence, 2nd edition, Schwickert and van der Merwe, under the heading The Criminal Standard of Proof, page 534 and 535. And if I could quote Nugent J, as he then was, in State versus van der Meyden, and the reference is 1999, Volume 1, South African Criminal Reports, page 447, Witwatersrand Local Division. The onus of proof in a criminal case is discharged by the state if the evidence establishes the guilt of the accused beyond reasonable doubt. The corollary is also that he is entitled to be acquitted if it is reasonably possible that he might be innocent. They are not separate and independent tests, but the expression of the same test when viewed from opposite perspectives. In order to convict, the evidence must establish the guilt of the accused beyond reasonable doubt, which will be so only if there is at the same time no reasonable possibility that an innocent explanation which has been put forward may be true. The two are inseparable. Now, with regard to the question of circumstantial evidence, because we are dealing with a case here that involves circumstantial evidence and inferences to be drawn, and the principles involved, may I once again refer the learned court to Principles of Evidence by Schwickert, and this time, page 505. In Rex versus Blom, it was said that in reasoning by inference in a criminal case, there are two cardinal rules of logic which cannot be ignored. The first rule is that the inference sought to be drawn must be consistent with all the proven facts. If it is not, the inference cannot be drawn. The second rule is that the proven facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If these proven facts do not exclude all other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. The second rule takes account of the fact that in a criminal case the state should furnish proof beyond reasonable doubt. Now, a very good example, which I will deal with in more detail later, but that sprung to mind in terms of circumstantial evidence and the inferences to be drawn, seems to me to relate to a point that was raised several times by my learned friend, and I suspect that he's attempting to wriggle into his case the suggestion of something sinister involved in the fact that when Captain Hubert examined the deceased on the Sunday, the 24th of July 2017, that her dressing gown, her bathrobe was inside out. Mentioned that a few times. And I think he's trying to link that up, I suspect, with the allegation that the accused, for whatever reason, put the dressing gown on her after Mr. Daniels had left the scene. Now that is an inference which he would like us to draw with a sinister connotation. But what he doesn't disclose is the following. That observation was made by Captain Hubert much later in the day, in the afternoon, in fact, of Sunday the 24th of July 2017. And note, the defense did not dispute the correctness of that allegation by Captain Hubert. It's interesting to note that Captain Hubert, in his own report, this is the state experts, in his own report says it's not at all unusual for patients, especially when they put garments on at night time, to put them on back to front. But more important than that, let us not lose sight of the following. Before Captain Hubert came on the scene, during the later afternoon of Sunday the 24th, that deceased had been fully and comprehensively seen and examined by at least one other person, namely Dr. Khan. Dr. Khan's examination took place at somewhere around about 1 o'clock during the afternoon. If he is to be believed, he examined that patient comprehensively. He also examined her entire back. How do you examine such a patient's back and make the observations that he made without taking off the garment that she's wearing? You can't do it. Secondly, Dr. Khan was never asked what the position was with regard to her gown, but what we do know is that nowhere in Dr. Khan's report does he mention having found the deceased to be clothed with her dressing gown or bathrobe inside out. So the inference that this emanated from some sinister conduct on the part of the accused flies out of the window. It's not the only one that can be drawn. And in fact, it's not even the most likely or logical one. Now, in these legal principles, I have set out in paragraph 7.14 the yardsticks, the measures to be applied when the testimony of an expert is to be evaluated and considered and assessed. In particular, when conflicting versions arise between experts, which one do you prefer? Which one must, and they remain. The well-known case of Michael versus Linksfield Clinic and others, an appellate division, clearly stipulates that the court evaluating such expert testimony needs to consider to what extent the opinion expressed is based on sound, logical common sense and scientifically justifiable reasoning. That is the test. And I submit that when the testimony and opinions of Dr. Khan, and to the extent that it is relevant, that of Dr. Abrams is taken into account, then on every single level for the evaluation of an expert witness, they fail dismally. Now there's one last point that I wish to raise, and I refer the court in this regard, legal point, to be taken into account. I refer the court in this regard to 2 or 3 authorities. The Principles of Evidence, once again, 2nd edition, Swickert and Panomerva, and in particular, page 509 and 510. The South African Law of Evidence, that's now the Zeffert, Pays and Skeen edition, that is paragraph 755, page 755 to 757, and then the old South African Law of Evidence by Hoffman and Zeffert, page 461 to 462, and I refer there to the concept of a failure to cross-examine. And the principle that is expounded is that if a party, and in particular a prosecutor, fails to challenge or cross-examine a witness on a point or on a particular issue, then that issue stands. It cannot later be argued that it stands to be rejected. Now, I found this particularly telling with regard to certain factual aspects of the evidence of Mr. Rohde, the accused, which were not challenged. I'll give a prime example of one. When the accused placed his wife on her back on the floor after the cord had been removed from her neck in the bathroom by Mr. Daniels, as he was on the point of commencing his attempted cardiopulmonary resuscitation, or CPR, he observed a trickle of saliva running down from the corner of her mouth, the left-hand corner of her mouth. He wiped that away and then carried on with his mouth-to-mouth respiration and attempted chest compression process. That was never ever challenged. I might just add that that point of the extrusion or the trickle of saliva was also put by me in cross-examination to Dr. Khan, who gave a somewhat unequivocal reply or response. That evidence stands. Another example, which is perhaps far more telling in this case, of a failure to cross-examine, is the following. Dr. Loftus's testimony, to my mind, demonstrated everything that is excellent in an expert. He was the epitome of a consummate expert. In an untrammeled and unemotional manner, he took the court through his evidence by means of clearly demonstrated PowerPoint demonstrations on various critical aspects to this case, and I shall deal with his evidence more fully hereunder. But I do submit that he was as good as an expert as one sees. Nothing that he presented in any one of those PowerPoint presentations, and they dealt with the ligature mark, the consequences of his observations. They dealt with the calculation of the time of death. They dealt with the rib injuries and the right pulmonary contusions, and 2 or 3 other aspects. Not one of those points was challenged by my learned friend in cross-examination. In fact, at the time I can recall stating to the court that I was absolutely taken aback by the brevity of the cross-examination, and for that reason I didn't have another witness available. I was expecting it to last for 2 days, and it lasted not even for 2 hours, not even for 20 minutes. Now, there is an implication associated with that failure. That evidence, that expert opinion, is unchallenged. Now, I move now to deal with the testimony of Dr. Khan first, then very briefly that of Dr. Abrahams, and I must just say in that regard, it is instructive to note that in his argument my learned friend places absolutely no reliance whatsoever on the evidence of Dr. Abrahams. He didn't in any way incorporate her and her opinions into his argument, and in fact shrugged her evidence off with the comment that she actually didn't perform the post-mortem examination. And I'll deal with her in a moment. Now, Dr. Khan's documentation comprises his curriculum vitae and Exhibit D. Also, reference was made during his evidence to the post-mortem examination report of Dr. Perumal, the mortuary file, and then the handwritten notes of the incident scene, the handwritten notes taken by him allegedly at autopsy, and then, of course, in addition, during his testimony, the affidavits of Mrs. Angela Norton and Mrs. Diane Holmes, the sister-in-law and mother, respectively, of the deceased, were handed in.
Sister-in-law. Sister-in-law.
As the court pleases, quite correct, I'm sorry. The accused sister-in-law, as the court pleases. Now, my summary of Dr. Khan's testimony is that his evidence simply does not stand the test of scrutiny and cannot be accepted. Most certainly, it can never be preferred to that of Dr. Perumal and that of Dr. Loftus. I submit with respect that in numerous significant and material respects, Dr. Khan let himself down completely in terms of demonstrating his acute inexperience, demonstrating serious ignorance of even the most basic forensic pathology principles, not telling the truth with regard to various matters, and incompetently performing the inspection at the scene and the autopsy. And I shall demonstrate those as I address the court. What is even more sad about his testimony, and even more so that of Dr. Abrahams, is that from the perspective of a very, very junior consultant, he compounded the error of his ways even further by resorting to attempted character assassination of Dr. Perumal. I suspect that that approach was heavily influenced by Dr. Abrams. Now, when Dr. Khan's curriculum vitae was presented through his testimony, at first blush, one heard an incredible, impressive array of achievements, qualifications, experience whatsoever. He testified in a manner that was brimful of self-confidence. Actually, the bottom line was that he was a very inexperienced consultant, and if I'm not mistaken, he had been on the register for about a year when he was given this high-profile case. And his inspection at the scene of the incident is where everything started to go wrong. If I may refer the learned court to Exhibit D and his inspection. I have his incident scene report here in front of me, and it is necessary at the same time to look at his handwritten notes of the inspection purportedly made outside the room of the hotel straight after he'd concluded his inspection, which is what he alleged, and then his incident report typed up a few days later. Now, the first point which raises a problem is the following. To this day, despite valiant, frequent, repeated requests, Dr. Khan has failed to produce his original handwritten notes. The defense has been blocked from examining them, testing them for authenticity, and has just been met with a brick wall every time this point has been raised. Nobody can tell us where they are. If that were an isolated incident in the context of this case, then one would shrug it off and say, oh, well, these things happen. But it's not, it's a pattern. And I will demonstrate that in due course. It's a pattern, crucial documentation and so on that is missing. And these notes and the authenticity of them was explicitly challenged in cross-examination with reference to the question of how could he know that the police reference number was the one reflected here, and how could he know what the mortuary number was as he sat in his car outside the inspection. And to this day, no satisfactory reply and response has been given. During the course of the inquiry of the case, I handed up a photocopy from the police registration computer showing that this number was allocated that same evening at 19:04 on the 27th of July 2016. And what are we met with? We can't examine his original notes. It's alleged by Captain September that he got the number when he arrived on the scene and provided it to Dr. Khan. Unfortunately, Constable Fernandez gave different evidence to Captain September and contradicted him. And then when Captain September was asked, well, please produce your police notebook where you would have written down the number. Yes, he would have written it down there, but no, his number has been, his little notebook has been stolen. And then the next thing is the computer was down. And then the following is when we look at the email exchanges that took place, or some of them that we're able to access, between Dr. Khan and an official at Paarl Mortuary, which were exchanged a few days later, we see this information being requested. Why is it needed if it's already obtained? Of more significance to me, however, is the disparity between the handwritten notes, the typed version thereof, and the incident scene report. Not to mention the autopsy report. I'll give a quick example. If you look at the handwritten notes, you will see it reflects the ambient temperature as 17.4 degrees centigrade, the body temperature as 24.3 degrees centigrade. You'll see the typed notes under body temperature reflect 2 question marks, and you will see that the incident scene report reflects a body temperature of 30.3 degrees. Not exactly very satisfactory. Another very, very salient point is the following. If you look at the handwritten notes, you will see, now remember, these are the contemporaneous notes, supposedly the most reliable source of everything. You will see, unless I'm missing it, absolutely no mention of any pallor of the tip of the nose or the lips or anything similar at all. Nothing. I look at the typed version and I look at the handwritten version. If I look at the incident scene report, I suddenly see the following emerging. The nose appears deviated with pallor noted to the tip of the nose. All of a sudden that appears. Then, when the submission is made by Dr. Abrams, and it's an objectionable submission, but it was nevertheless made, that on the basis of pallor of the tip of the deceased's nose, pallor of the lips, and a tooth imprint on the inside of the bottom lip of the deceased, she can conclusively arrive at the opinion that she was smothered to death. The situation becomes laughable. But the incident scene report and the mendacious evidence of Captain Steenkamp and the later emails aside, to me, the two most crucial issues arising, and which are devastating for the credibility and acceptability of Dr. Khan's evidence, or 3 issues, are the following. If you look at his incident scene report, you will see under M, paragraph 5M, the following. Post-mortem lividity, in other words, hypostasis, is well established. Now remember, he was looking at the deceased lying on her back in the bathroom of the hotel room 221 at Spuy. We know that she'd been lying on her back there from about 8:30, and it was now about 4.5 hours later that she'd been lying on her back when Dr. Khan arrived on the scene. Post-mortem lividity is well established, fixed and located posteriorly on her back. He says, with contact pallor over the shoulder blades and buttocks. He can't pick that up over the shoulder blades unless he takes off her gown. Then he says there is no lividity noted anteriorly over the lower limbs. the features of lividity is not consistent with death in an upright position. The post-mortem lividity would indicate death in a supine and lying position. And there he made an error that was as fundamental as forensic pathology 101. It displayed a degree of, or a lack of knowledge that was astonishing. Because he equated, despite all the authorities indicating that you can't, including his own authorities, I might add, with particular reference to knights, contrary to all the authorities which indicate that you cannot use lividity to tell in what position a person died. All you can use lividity or hypostasis to do is to indicate in what position the deceased person was for a period of time after death before lividity set in. In other words, translating that simply into the present case, if you die in a hanging position and you are cut down within an hour or a bit longer, maybe 2 hours, before lividity sets in, and then you lie on your back thereafter for a period of a couple of hours or more, lividity is going to set in on the posterior aspects, on the back, on the buttocks, the back of the legs, etc. You can't use lividity to say in which position a person died. And that error was so fundamental on his part that it immediately raises the question regarding his experience and competence. But that's not all. On the strength of his observations at the scene of the incident, he came to a conclusion that the death of the deceased had occurred with a 95% probability at 5:40 a.m. on the morning of the 24th of July, 2016. He also saw some major bruising on the inner thighs of the deceased and postulated the strong possibility that she was the victim of a battered wife syndrome, and everything fitted together in his mind. There's some blood on the pillow and on the sheets or duvet. It's alleged that the patient hung herself to death, but on his incorrect interpretation of the lividity, she didn't hang. She's a battered woman. She's got several, or not several, but quite a few cuts or an abrasion on her left eyebrow. And what does he conclude? He concludes that she's been assaulted and murdered, that her husband is a suspect. He must be a suspect. And of course, if you add to that the time of death that he postulated, and you read with that the fact that it is known, but it was by then established, that the mobile telephone of the deceased that was found in the bathroom with her reflected an SMS that was sent at 12 minutes past 7 that day, the conclusion is irresistible. through a cacophony of accumulated incorrect assumptions that foul play has occurred. And so, what does Dr. Khan do? He unfortunately descends into the arena, gets the dust of the arena in his eyes, and makes the most fundamental mistake that all forensic pathologists are taught at all costs to avoid, and that is, don't arrive at a premature conclusion, because it will influence every single thing that you do and conclude thereafter. Your main investigation is the autopsy, and only reach a decision once you have all the facts and once you've performed an autopsy. And even then you might need special investigations, and you might still be unable to reach a conclusion. But no, he bumbles headfirst into the matter and descends to the arena to the extent of doing the following. And this conduct has been categorized, and it was put to Dr. Khan as outrageous. It was recommended by him to the police personnel, namely Captain Gogotja, present at the scene, that the case should be investigated as a possible homicide, and that the husband should be taken to a clinical forensic medical practitioner for further examination and documentation of any injuries sustained to his body. It was also recommended that his passport be removed until investigative process is complete to prevent him from fleeing the country. That was totally outside the ambit or spectrum of his remit. But so involved was he with the prosecution, or the potential prosecution of this case, that from then onwards he was never able to see the wood for the trees. So what we have is, and I will deal with it in a moment, a shockingly poor incident scene inspection. We have fundamentally incorrect conclusions, and we have Dr. Khan setting himself in a train of thought and setting into motion an approach that inevitably colored every single thing that he did thereafter. Now, I want to just, before I leave the incident, I want to just emphasize one aspect relating to the calculation of the time interval. Even when one watches TV soap dramas and similar programs involving detection and the police, it's pretty clear to a layperson like me that estimating the accuracy of the time of death is fraught in the extreme. Yet this junior practitioner is able to go into court and state under oath repeatedly that it is 95% probable that she died at 5:40, with all the implications thereof, the adverse implications towards the accused. What happened, of course, was that it was ultimately established that his evidence and report in that regard was not worth the paper it was written on, figuratively speaking. It was forensic nonsense. At best, even if one relies on the accuracy of his figures, of his measurements taken at the scene, and thereby hangs a very serious question. At best, he could have said there is a 95% probability that the deceased died at approximately 3:40 a.m. to I've got to add 2 hours and 48 minutes on to 5:40.
8:28.
8:28. Mr. Good. That's the best that medical science can tell. But he can say it at 5:40 with a 95% degree of accuracy. The astonishing thing is that it took so long in cross-examination to extract the admission from him that his methodology was totally incorrect and his interpretation of his results was totally wrong. But think of the implications of that in this case. Now she didn't die at 5:40. Now she could have died at any stage up to 8:28. It's a different ball game. If I could refer the court to just 2 places in the record, and that is page 339, and I'm just going to quote it very briefly on line 11. What you said when you testified in chief was that there was a 95% probability that she died at 5:40, which doesn't have the trappings of being fraught with inaccuracy in my book. Now, then, more importantly, from page 395 to page 407, 408 of the record. I'm not going to go through that whole lot, but it summarizes the disaster of his evidence in this regard. Because any reliability that stands to be placed on his evidence or testimony or opinion as to the time of death is, of course, also dependent on the measurements that he takes and the accuracy of those measurements, and whether he takes into account specific aspects that are mentioned in his own authorities that need to be taken into account. I'll give an example. If there's a blanket over the lower portion of the body of the deceased, that is a factor that needs to be considered and factored into the whole exercise. That's just one example. Now, on page 408, I say, now, doctor, this is now where he's now being corrected. And remember, his evidence was the following: that the 2.8 hour interval before and after 5:30, either before or after, that fell within the 5% range of that 100% accuracy. So 95% certain that it's at 5:40, but with a 5% chance that it could be 2.8 hours either way. One wonders, what does that imply in terms of damage to the accused? And one also asks oneself the question, what if his bona fides had been accepted by an accused who did not have the advantage of access to experts to advise him? How does justice work? But the irony goes further. In reaching his point in the graph of 5:40 as the starting point, and remember, I handed in later authorities which were written by Hengsi, Knight, Medea, all the top experts, saying it is absolutely wrong to use the mean. It is totally misleading. I even showed the book through Dr. Reggie Perumal. But he also didn't do the following. Page 408. Now, doctor, just give me these times again, please. I can't remember. And he says 2:52 to 8:28. So those are so it's now 95% at any time between 2:52 a.m. and 8:28 in the morning. And isn't it ironic that the 8:28 seems to me to coincide just about exactly with the evidence of Dr. Loftus that death was still in process of taking place. At the beginning of the CPR attempts, when she had been placed on the floor, the Rubicon might have been crossed, but death was still in the process of taking place. It hadn't finally occurred. But let me read further. Right, Dr. Khan, but that's only correct to the extent that your methodology is correct. And we've shown up about 5 or 6 errors in your methodology, starting with not taking proper cognizance of the red blanket, not measuring the floor temperature, not taking the mean temperature between the floor and the atmosphere, the difference between the bedroom and the bathroom temperature, the difference between a sunlit bathroom window and a non-sunlit bathroom window. And other possible factors are the body, and then there was something indistinct, and I think I said there the body mass index, which he didn't take into account, body mass index, and the alcohol intake. So actually, I want to get back to the point that I'm making, and that is that your evidence isn't worth the paper it's written on. And he says, right. No comment, my lady. Now that is the witness that my learned friend says we must rely upon beyond reasonable doubt as to the cause of death. And I haven't even started, because we now move on to the next aspect of Dr. Khan, and that is his autopsy. Now, possibly while I'm on the time of death, I might just point out an aspect of dishonesty, or let me be fair to Dr. Khan, an error on his part. He categorically stated in his evidence that Dr. Abrams had no part whatsoever to play in terms of finalizing the incident scene report. It's on record. He drafted that. He had some other activity on the Monday, so he only finalized his report on the Tuesday, which would have been the 26th, and he then emailed it through to her. That was it. But actually that's not true. We have on record the email that he sent to Dr. Abrams in that regard. We have on record the draft incident scene report that was attached to that. And I refer the learned court to Exhibit V1, and we can look at that and compare it with his final report, and we see that it differs materially. And the difference, as per Dr. Abrams, was that in the initial report he made a mess up of the calculation of the time of death and the interval, and she corrected him. And what we now see, although accepted by him, in his incident scene report in paragraph 6 is actually the product of her input. Well, that's a sad indictment of Dr. Abrams. That's all I can say. And it reflects unfavorably on Dr. Khan. Maybe he was trying to protect Dr. Abrams. I don't know. You see, the court will bear with me. And so I submit that a combination or admixture of ignorance, inexperience, and error set in motion a train of events that effectively precluded a proper, objective, scientific approach on the part of Dr. Khan from then onwards. And what a pity he did not have available to him at that point, at the autopsy, a true expert who could put him back on track and guide him from then onwards. Now, the autopsy was incompetently performed, and the interpretation of the findings that were made was utterly flawed. But I do want to point out something else. In regard to note-taking, it was the testimony of Dr. Khan that he performed the autopsy on the deceased. This was the first autopsy. That he did that on the 26th of, or the 27th, 26th, doesn't really matter, of July 2016. And that he made his own notes, his own handwritten notes as he performed the autopsy. Now, when one bears in mind that when you perform an autopsy, you're gloved up and you're working with tissue, there's blood involved, there's body fluids involved, and the question immediately arises is, how on earth do you make notes? Do you make them afterwards? In my experience, most practitioners either make use of a dictaphone process where they press a button with a foot, or they have a scribe who writes down the notes. But no, says Dr. Khan, he made the notes by every step of the way. He would stop, wash his hands, dry his gloves, then make a little note, then back to the autopsy. So I would like to see those original notes. Inevitably, a drop or two or more of water would be on them. There would be signs. Were they contemporaneous or not? Especially when there is a flaw in those notes that is fundamental. Two, in fact. But no, those notes have vanished. Once again, missing information and documentation in this case. And if you look at those notes, and you look at the absence of the originals, and if you look at his final report, and if you take into account the fact that it took 9 months after the autopsy to squeeze the autopsy report of Dr. Khan out of the state, 9 months before they made it available to the defense, when Dr. Perumal's report was made available at the bail hearing within a week or two of the death, then one can't but think that something fishy is going on. And this is compounded when one takes into account the evidence of Dr. Perumal. According to Dr. Perumal, as a courtesy, something he does in all his cases,
if he's doing a second post-mortem, and he often gets requested to do second post-mortems, he's very experienced in doing second post-mortems and avoiding the pitfalls associated with second autopsies. Out of courtesy, he phoned Dr. Khan, told him that he was going to perform a second autopsy, and invited or gave Dr. Khan the opportunity of attending, which of course he didn't. He says that Dr. Khan, in the course of that telephone conversation, said to him that you will find that the hyoid bone has been fractured. Now let's just put it on fast forward. He then performed that post-mortem, and to his observation, the hyoid bone was intact. It was not fractured. He could see no fracture. Now he was concerned. If the hyoid bone was found by Dr. Khan to be fractured, and Dr. Khan placed significance on that fracture in terms of whatever his findings were, and he, Dr. Perumal, found there was no fracture, then there was going to be a fight somewhere down the line, a dispute. So he picked up the telephone and he phoned the instructing attorney, Mr. Daniel Witz, and he said to him, listen, there's this problem. Dr. Khan told me that the hyoid bone was fractured.
And for the sake of proof, please give me authority to perform certain special investigations in terms of that hyoid bone. And what emerged was Mr. Witz telephoned the accused gave him authority, and I'm talking now about several thousand rand being
involved, because inter alia a CT scan was required, and a CT scan and x-rays of the hyoid bone were taken, and we have them in front of us, and no fracture was demonstrated. Now Dr. Khan denied having told Dr. Perumal that there was a fracture of the hyoid bone. Later in my address, I'm going to place on record and deal with the court with all the aspects in this case that have either been admitted or are common cause. One of them is the affidavit, the very last exhibit in this case, of Daniel Witz. And just for the record, that is exhibit, I think it's KK, yes. And in that affidavit, he confirms having received that call and that information from Dr. Perumal. He confirms having contacted Mr. Rohde, having got the authority, and he attaches the emails that were involved. Now, Dr. Khan denies that he told Dr. Perumal that the hyoid bone was fractured. He denies that. My learned friend admits the contents of Mr. Witz's affidavit, but without admitting that Dr. Perumal conveyed the correct information to him. But I ask you, with the proverbial tears in my eyes, why on earth would Dr. Perumal go to the extent of having a CT scan and x-rays of the hyoid bone specially performed and remove the hyoid bone and keep it to have in court if he hadn't been told by Dr. Khan that there was a fracture? But that's not all. There's a mystery. If we look at Dr. Khan's typewritten notes, Exhibit F1, if I can just get to F1. F1, it comprises 4 documents. The handwritten notes allegedly made by Dr. Khan at the scene, and the handwritten notes allegedly made by him during the course of the autopsy. These are the ones that he made every time when he wiped his hands dry and so on. And if we look at the handwritten notes at the autopsy, we see the following. And this has been demonstrated by Dr. Perumal and without a shadow of a doubt by Dr. Loftus. We see a so-called hash sign and then an L in a circle, post-Hyoid. And that, in all generally universally accepted medical terminology, means there is a fracture of the left posterior hyoid. It can mean nothing else. And that ties in totally with what Dr. Perumal said. So we have a serious credibility problem there. But that's not the main problem with the autopsy performed by Dr. Khan. Now we have the unusual scenario with Dr. Khan. He came into court on a high. He oozed self-confidence from every pore when giving us his CV and presenting us with his results. And inter alia, roundly criticizing Dr. Perumal, a colleague of 30 years' experience, and then coming down to earth with such a bump at the point where I quoted earlier to the court, up to page 408, where he was booked off by a psychiatrist for 3 or 4 weeks. He then comes back to court, and the cross-examination continues. I've drawn up a list of things that, with respect to the autopsy, he either missed or did inadequately, incorrectly, or incompetently. No x-rays were performed. When you're dealing with a fracture of the hyoid or an alleged, as it was later the case, fracture of the thyroid, the horn of the thyroid cartilage, which incidentally also does not appear in that report that I read, that handwritten note, then you take a scan to confirm it. He did no histology whatsoever, nothing. I will, when I deal with Dr. Loftus's testimony, deal with the benefits and potential advantages of histology. But just at this stage, let me say one thing. One of the potential advantages of histology in this case was that it could possibly confirm that the ligature had been applied, that is the one that was used for the alleged hanging, whilst the patient was alive, whilst the deceased was alive. Because that's really the crucial question. Was she murdered, strangled, smothered, whatever, in the room, and then carried or dragged or manhandled into the bathroom, where the ligature was applied round the neck of her dead body and then strung up on the back of the door by Mr. Rohde in his masqueraded, simulated suicide? Or was the cord applied around her neck by her herself when she was still alive in the bathroom? That's the crucial issue in this case. The next mistake that he made related, of course, to his assessment of the position at death and his misinterpretation of lividity stroke hypostasis. The next mistake he made was incorrectly to take into account the massive bruising that she had to her legs and his belief. And that belief persisted until just before his evidence in chief ended. The court will recall that there was an adjournment, and then he was, at a late stage of his evidence in chief, handed the affidavits of Mrs. Holmes and Mrs. Norton. They're part of the record. They are exhibits G1 and H1. He was shocked when he read those affidavits. You could see it on his face. Because he had asked, according to him, if he's to be believed, and quite frankly, if I have to choose between Sergeant Apollos and Dr. Khan, then I will believe Dr. Khan every time. He was told by Sergeant Apollos that, positively and categorically, that the deceased had no medical history of any note whatsoever, of any significance. He was told that at the autopsy. That's Dr. Khan's evidence. Sergeant Apollos on that point was as vague as to be embarrassing. But anyway, on the strength of that bruising, he concluded the battered wife syndrome, and there was a whole cross-examination on that. He totally got the time of death wrong. Then he missed a whole host of injuries. The first thing is, Dr. Khan missed the ligature mark at the back of the neck. And it was interesting to see the whole dynamic around that injury, that mark on the back of the neck, and how he and Dr. Abrams wriggled to try and explain something that was very simple. As it was put by Dr. Perumal, they made an observational error and they missed it. Because you can't argue against the photograph that Dr. Perumal brought to court as part of his album. The problem is, when Dr. Perumal's post-mortem report was made available to the prosecution, they weren't given the photographs that he'd taken at the autopsy at the same time. The supreme irony is that at a later stage they cried, "Foul! The photographs were not given to us." What a joke, with respect, when the entire autopsy report of the state was not available to the defense. But in any event, the immediate reaction of Dr. Khan, and it shows the sad influence under which he obviously functioned, was that this was a deliberately caused artifact. In other words, some horrific suggestion of conduct on the part of Dr. Perumal or somewhere else who had created those marks to create the impression of a ligature mark on the back of the neck. Luckily, that suggestion was soon dropped. And in any event, through the evidence of Dr. Loftus, it was discounted. Then another attempt was made. No, that mark was caused by the block that is used when a bloodless neck dissection is performed. Well, that was shot down in flames, with respect, by both Dr. Perumal and Dr. Loftus. Dr. Loftus, who has performed thousands of postmortems, has never seen, using the block too, has never seen that type of injury, and he says it's impossible. At the time when the block was used and the first autopsy was performed, lividity or hypostasis had been fixed for 24 or 36 hours already. There was no way that it could be influenced by a block, but in any event, the location of those marks on the back of the neck was perfectly in line with the other marks, ligature marks, and it wasn't where the block would sit if a proper bloodless neck dissection is performed. Then the block is positioned under the shoulders, not the neck. So the bottom line is Dr. Abrams and or Dr. Khan missed that on the back of the neck, and they have no photographs to show their finding. My lady, is this a convenient time for?
Yes, Mr. Van Spuy, I just want to ensure that we are working, you are working on in accordance with time, so that we don't run out of time today. Are you good for that?
I'm keeping my fingers crossed the whole time, my lady. I think I will be finished by 3:30.
You have to be done by latest 3:30.
My lady, I'll go as fast as I can. I trust that I will be done, but I have a job to do.
Indeed you have. I have your heads, and the purposes of argument is not to rehash all the evidence. But we will adjourn for 10 minutes and be back by 11:30. Thank you.
As the court pleases.